Yes, Mr. Ramlogan.
My lord, good morning. Are you hearing me clearly?
Yes, we can hear you very clearly, thank you.
Much obliged, my lord. My lords, my lady, I lead Mr. Daniel Goldblatt, and we're instructed by Mr. Jared Jagru of Freedom Law Chambers for the appellants in this matter. My learned friend, Mr. Anand Biharilal, King's Counsel, leads Ms. Candice Barrett Nahus for the respondents, and Ms. Kate Temple-Mabe, instructed by Mr. Kent Samlal of the Trinidad Bar, appears for the intervener, Ms. Chandra Somai, pursuant to leave granted by the board.
Yes.
My lord, in announcing the appearances, I'll immediately make a short point, which is that the respondents might require formal permission from the board to appear today, and that is simply because they had failed to file their acknowledgement within the required prescribed time of 21 days service of the notice of appeal, and the rules do so provide. It was only we were only provided with an acknowledgement on October 30th, 2025. After we had chased them up for a substantial period of time with no response. And of course, whilst they filed their written case and all of that, there's been no explanation.
Would you oppose leave being granted, Mr. Ramlogan?
No, I don't, my lord, no, because I think it's in the best interest of justice that they be heard in this matter. So I just point for the record. Now, my lord, I should say, my lord, that I'm ill this morning, and I will be making some brief introductory remarks. But rather than cough and splutter through my submissions, I have yielded to my learned junior, Mr. Daniel Goldblatt, whom I've had much discussion in preparing for this morning to do the substantial submissions. My lord, in this matter, as another item of housekeeping, Mr. Bisundat Ragoonanan, the eldest child, who is the fourth claimant, now the fourth respondent, is deceased. There's been no substitution, as far as I'm aware, by the respondents, and therefore his estate may not be properly represented before the board as such. So I just made them embrace that as a footnote, because I haven't seen any application for substitution in respect of the fourth respondent who is now deceased. In respect of changes, we now have a situation where two of the respondents have indicated to the board through their counsel that they are now in support of this appeal, and that is the first respondent, Lutchmienarine Ragoonanan, and Vindra Richter, who is the third respondent. At page 1803 of the record, you will see a letter from their counsel indicating that they are basically more or less in support of the appeal, and they have no objection to the appeal. Other than that, the parties that are concerned with the appeal in terms of the respondents would be Ms. Prema Wheatley, who is the second respondent and who is ordinarily resident in England, Ms. Angie Jubb, who is the fifth respondent, who lives in Virginia, Mr. Krishna Ragoonanan, who is the fifth claimant, fifth respondent, who lives in New York, Mr. Suresh Ragoonanan, who is the seventh respondent, who also lives in New York, Ms. Kokela Susie Taylor, the eighth respondent, who lives in the United Kingdom, Mr. Heyman Ragoonanan, the ninth respondent, who lives in New York, and Mr. Harry Ragoonanan, who, as indicated before, is deceased, not a party to the proceedings, as he died before the claim. Well, he died before the claim was even filed. Now, I make good that roll call simply to illustrate the point that the respondent, Vashti Ramlal, and the brother, Mr. Lutchmienarine Ragoonanan, are the only two siblings in this unfortunate saga who actually live in the island of Trinidad.
Yes, we understand that.
Yes. I make that point because I think it's of, it might be of some significance in terms of contextualizing the evidence and the way the judge analyzed the evidence as to why we say quite rightly, found that the father would have indicated an intention, evinced an intention to give them an identified and specific parcel as being representative of their undivided share in the subject parcel of land. Now, my lords, the appeal concerns a parcel of land in Trinidad that was left to 12 children by their father. The rights of the first appellant to a portion of that land known as the land on the hill, and whether a house built there should be demolished against the wishes of all the parties. Now, my lord, the trial judge, the Honourable...
Sorry, can I just interrupt you a moment, Mr. Ramlogan? You say against the wishes of all the parties, including the appellants.
Yes, indeed, on the demolition, on the issue of the demolition, yes.
Can I just confirm that with Mr. Vashti Ramlal? Is that right, that the appellants are also opposed to that part of the order under appeal?
My lord, no. The named respondents who we appear for have confirmed that now that they understand the position with the land, that they do wish to support the order for demolition.
Right. Did you hear that, Mr. Ramlogan?
I did not, I'm afraid, my lord, sorry.
Mr. Vashti Ramlal was saying that those whom he represents now support the order for demolition.
Well, my lord, I wasn't aware of that, and that's certainly a significant U-turn from what was represented to the Court of Appeal after judgment had been delivered and the court had sought submissions. But my learned friend, Mr. Goldblatt, will no doubt highlight the relevant parts of that. But in any event, we say that the court was wrong to order the demolition in any event. The learned trial judge on this matter heard extensive oral evidence and had the opportunity to observe the witnesses on the demeanor and attitude and so forth under intense cross-examination and made findings of fact. She dismissed the respondent's trespass claim and granted the appellant's declarations that the first appellant was entitled to the land on the hill as her share, as being representative of her share in the deceased estate. Now, my lords, we say that the Court of Appeal was wrong to overturn these findings of fact that were carefully crafted by the trial judge, who carefully analyzed the evidence. It is true, as the Court of Appeal said, that in the deceased's will, he left his estate to his children in equal shares. But there was no inconsistency with that, and the oral indication of a communication of an intention to give an identified parcel of land as being representative of their undivided share in the parcel of land, we see. One might be complementary or supplemental. But
well, that's not right, is it, Mr. Ramlogan? If you give property to somebody in equal shares, you're giving them an equal share of the whole undivided property. And that's inconsistent with some putative division.
Well, my lord, it could be, I accept, but not in the face of the evidence in this matter, which the trial judge accepted as the truth of the facts, which is that the father did in fact evince an intention which he communicated to all the children, and it was well understood.
Well, he may have done, but there's a formal way of communicating your intention after your death, and that's by making a will. And in fact, you've had conversations beforehand. Is neither here nor there when there's a formal document that declares your intention, which is inconsistent with the suggestion that anybody has anything other than an equal share in the undivided whole.
Well, I can obviously see the force in that, but the evidence was before and after, and to the extent that that was the common understanding and intention of the deceased. In the context of evidence where these are the only two siblings that actually resided on the property and live in Trinidad, and this was the daughter who took care of the parents in their winter years until death. And you know, it's well known in our social in Indian culture and in many societies that is something that parents do, that they would want to, the child that looks after them in the winter of their years, that's the child that they would want to actually, look after and seek their interests. I mean, Vashti was married, and when she was married, this was a parcel of land, this was the area that was pointed out, and the intention was articulated and communicated even then.
But presumably the father knows about what a will, the significance of a will is, because he made one. And he must have known that the point of making a will is to declare your intention formally for what's going to happen when you die. And if you want to change that, you can easily make another will. It's not that difficult. And he didn't. So that's it, isn't it? I mean, we've got the will.
My Lord, I appreciate that, my Lord. And I think the way the judge analyzed the case, it really had to do with what might have obtained in equity in terms of whether there was a proprietary estoppel of sorts, having regard to the representations that were made and the clear reliance on it by the appellants.
No, we understand. We understand, Mr. Ramlogan, that given that there is a formal will, the only evident way in which you could try to overcome its provisions would be through a proprietary estoppel. The difficulty, as it seems to me at the moment, is that the case wasn't pleaded or presented in that way on behalf of your clients. Although I appreciate you're trying to run the argument now, but we're at the stage of a second appeal.
Yeah, my Lord, we were not involved in the matter in the courts below, and I appreciate that. But what we say to that is that in substance and effect, even though the words promissory estoppel was not used in the pleadings, it's clear, as the Court of Appeal said, that the judge implicitly and the parties understood the case to be one of proprietary estoppel, and the judicial analysis and reasoning was predicated on that basis. And we say that in substance and effect, that is precisely what happened, and the judge was correct to so analyze the case, having regard to the evidence that was led before her. Sorry, my Lord, excuse me, sorry. My Lord, and we say that the minority judgment by Justice of Appeal Raj Kumar, was correct in the reasoning that he gave. But my Lord, may I just at this stage just pass the baton to my learned junior, Mr. Goldblatt, so that he can take it from here, my Lord.
Yes, thank you. Yes, Mr. Goldblatt.
Thank you, my lords, my lady. I have three submissions. The first is that the Court of Appeal erred in overturning the trial judge's finding of fact regarding the promise. Our primary contention is that the existence of the will is not inconsistent with the fact that the father promised the land to Vashti, his daughter. I apologise for using in advance using first names, but I do so for brevity.
Yes.
I mean no disrespect. Second, it submitted that proprietary estoppel was sufficiently pleaded and made out on the facts. And third, that the order to demolish the concrete building by the Court of Appeal was wrong and unjust and should be reversed.
Do you accept that you have to succeed in proprietary estoppel in order to succeed on the appeal?
My lords, I say that our submission is that if we are, I appreciate this might be riding two horses at the same time, but if we are correct that the promise was made and that it was wrong for the Court of Appeal to overturn that finding of fact, we seek as an alternative a declaration that the promise, a declaration rather than entitled to, that a declaration effectively varying the High Court judge's order that the promise had been made, because we say going into any sort of any sort of partition proceedings, that sort of finding will be consequential to the decision of partition where equity is becoming involved, and determining how partition should occur or even influence the parties in respect to agreement for partition.
The trespass claim, what's the status of that now? That was dismissed by the judge.
Yes.
I don't think that was
not
disturbed by the Court of Appeal, and that's not before us. So the trespass claim is out of the picture, but that the judge may have thought that, well, if it's not trespass, then she must be entitled to the land, but it's that may be a non sequitur, which is what the Court of Appeal thought, I think, that even though she's not a trespasser, Vashti, that doesn't establish her right of ownership to the land on the hill. Is that a fair summary of where we're at the moment?
My lady, that is how the Court of Appeal did
Yes,
it.
yes.
But we did have a counterclaim for the declaration.
Yes, no, I understand. I'm just trying to work out where the two claims are at the moment.
Yes, so
yes,
the trespass claim is out.
is out, right.
A problem with a case based on promissory estoppel is that the equity would have been against the now deceased, and therefore it would be enforceable against his estate. But the estate wasn't made party to the proceedings.
No, my lord, that seems to have been a mistake on both parts, because for a derivative claim, which was to be brought by the respondents, they also needed, as a matter of substance, to bring in the executor.
You couldn't advance a case based on promissory estoppel without having the executor as a defendant.
Well, my lord, not. We say there's two parts to that answer. The first is we're here today with the executrix being a party, so any declaration would be binding. The second part is to say that there is an argument that one can still raise a proprietary estoppel claim against future property, and there may have been, as seen by the evidence examined by the judge, acquiescence by the other siblings as to that promise. And so that too could found a proprietary estoppel as against those other parties.
Yeah. I appreciate you and your leader have come into the case at a late stage, but there seems to be an element of retrofitting.
My lord, I wouldn't seek to characterise it in that way. I'd simply characterise it as getting to what the substance of the case is, and trying to reorder a case that may have been messier further down below.
Yeah.
Mr. Garber, you say that the resurrection or the restoration of a finding that in fact the father made this promise, by which I think you mean a promise that your client would get that property as her share after he died and his widow's life interest had fallen in, might be relevant in any partition proceedings. I can see how in theory or in abstract theory it might, but what partition proceedings are there? There's no discretionary power, is there, in an executor to partition that which has been left, a piece of property, this land, which has been left to beneficiaries in equal shares, in undivided shares, unless they all consent.
Yes, my lord. The two options for the executrix would be either to get agreement from the beneficiaries, or to get a court order, in which case the court.
But the court couldn't do it without agreement. Why can the court direct a partition to which not all the beneficiaries agree? What power is there in the court to do a partition in that situation? I'm in Trinidad.
My Lord,
there isn't, I think, under the Trusts of Land and Appointment of Trustees Act in the UK, but I appreciate that's probably not in force in Trinidad.
My Lord, I believe powers of petition were originally introduced under Henry VIII Act.
Right.
But from the authorities, I mean, it's briefly touched on in a Privy Council case that I hope the board has before it was sent last night.
Yeah.
It's from Fiji, Patel case.
This is the 1954 case. Yes, they do.
Yes, my lord.
Yeah.
I don't pretend yet to have studied it.
No, my lord, I didn't intend to take you in detail.
But can you just tell me, are you saying that the court has a power to, if you like, order that the estate be administered on the basis that rather than the beneficiaries all having shares as tenants in common, undivided shares, that the land be partitioned between them, notwithstanding that they don't all consent.
My Lord, the power of the court when it is undertaking a partition exercise, in my submission, would be a court of equity. So,
I appreciate that.
So it would be able to do what is equitable, and it could balance that lack of agreement against, say, evidence of that promise having been undertaken in detriment.
If it has the requisite power, I can understand why the giving of the promise might be relevant to the exercise of it. But I'm stuck at the previous stage, which is why does a court of equity have power to determine that a property which is at the moment, albeit it's in the unadministered part of the estate, has been gifted to beneficiaries as tenants in common in undivided shares, can be partitioned? Is there some general equitable jurisdiction to partition anything that happens to be held in undivided shares?
Yeah, my Lord, my submission is that the court has, when an application is made for partition, that gives jurisdiction to the court to decide.
Well,
in England, there seems to be something called the Trusts of Land and Appointment of Trustees Act 1996, which I've not had to deal with. But whether there's a counterpart in Trinidad, we haven't been told.
My Lord, they were predating.
That act doesn't seem to include that power unless the beneficiaries consent.
My Lord, the original power, in my submission, the original power to partition was a power to partition on the basis of what... I mean, my Lord Briggs, I think, was involved in a partition decision.
Well, maybe I was. In which case, all I needed to be is reminded.
I appreciate... I don't have the case before me, but I appreciate it was a case involving two parties who bought land commercially together, and there wasn't agreement as to how it should be divided, and the decision... I will make a note to get the decision before the board. But... the decision there was not to split the land perfectly 50-50 according to the value of the land. The decision was taken to split it as to how the parties had been using the land previously.
So
well,
how would...
if you can give me the case reference, that would be...
I'll endeavour to do that. I believe part of the basis for your decision, my Lord, I have to concede, was that would reflect the true arrangement between the parties that they would each have management of different parts of those lands.
Yeah.
So how would this play out then if there weren't a dispute? So the father dies, he leaves the will with the executrix to the 12 siblings. She then gets probate and she assents the land, all the land to each of the 12 of them in undivided shares, so that you've got a plot of land which is all owned by 12 people. Forgetting the fact that
assumes we don't win on the proprietary estoppel.
Well, no, I'm just in an alternative universe where with another family, say. So suppose this happened. It goes. So they all, following the distribution of the estate, they all then own this land. All 12 of them own all the land, and then they have to either agree amongst themselves how to divide it and then go through the process of partitioning it then. Do they? They would then have to apply to the court to partition it, and they could either say to the court, well, we've all agreed, she gets that bit, I get that bit, and divide it up, and then presumably the court would agree that. But if they go to the court and say, we don't want to hold this in all together, all of it, we want to divide it up, but we can't agree how to divide it up. Oh, court, will you split it up? This is what's happened in the past, these are who wants this bits, and then the court will petition that on the basis that they no longer want to own it all in common. they want it partitioned, so the job for the court is to decide who gets what bits. Is that how it would work?
Yes, Madam.
Or the court could just order the land to be sold, and the land to be,
Right.
proceeds to be divided.
We're all familiar with a situation in which tenants in common of joint owners of land fall out, and ultimately the court says, well, it'll have to be sold.
Yes.
What I'm not familiar with, but apparently I may have participated in some judgment that says you can do it, is that the court in that situation can say, well, actually, no, we're not going to sell it, we're going to partition it.
Well, my lord, under the partition ordinance in Trinidad and Tobago, which I think is referenced in some of the judgments but is not before you, what it does there is gives the courts the power to order the sales, which it didn't have previously. All it had was the power to order partition.
Oh, I see.
And I think the power to order sale in a partition was only introduced in this country, I think, in the 19th century.
Where did the power to order partition come from in Trinidad? Because in England it came under Partition Acts, I think, which were then repealed and replaced by other legislation.
In my submission, it's a common law power and has been described by this board.
Well, it wasn't under the English common law, because that's why a statute was needed. Before that, I gather that, wasn't it? I mean, isn't that why it came in many centuries ago?
My lord, that is my understanding of the chronology, but I do say how it has been described by this very court.
All right.
And I can quite see that looking at the general merits of the matter, though you want to divert this, that where you have 12 children, 3 of whom I think live in Trinidad and all the rest have gone abroad to make their lives elsewhere, 9 might want money and 3 might want bits of land. So one can see why a court might be, as it were, tempted to go down some kind of partition route that wouldn't necessarily mean partitioning it into 12 chunks. It might be 4, 3 small ones and then 1 big one for everybody else, which then gets sold. But as I say, I'm looking to see where the power is.
My lord, I think on a reading of the partition ordinance,
Okay.
there must be a pre-existing power.
Is that in the bundle?
My lord, the ordinance is not, but the reference to it, I can find for you
We can probably
in other
get it.
cases.
We can probably dig it up quite quickly.
Well, we don't have to decide the case now, but the partition will still have to be in equal shares, won't it?
In my submission, it wouldn't need to be.
It wouldn't. If people own land as tenants in common in equal shares, the court has power to divide it up some other way. I can't understand that.
Well, my lord, for example, if it were to order a sale as part of the partition,
Yes.
it would be able to do equitable accounting to take into account all the money that, for
Oh,
example,
I see, that have been spent. Yes, of course it would, yes.
that's an example of it not dividing that share.
But they would start with an equal division on sale, but then there would have to be taken out into account some expenses that people may have incurred or that sort of thing.
Well, I mean, this gets to the appellant's submission that in that partition, it would be partitioning 12, 12, 12, 12, 12, 12, 12, but we would seek to use the declaration of the promise to say that we are entitled to that specific 12, which is the land on the hill.
Or at least to some part of that 12 that wouldn't give you too much, i.e. more than a 12th. Which seems to be what everybody was concerned about that led to the litigation in the first place.
Yes, my lord, and that it does. I mean, I've been slightly taken off track.
Yes. Sorry.
But I was going to take you to the emails from the respondents where they ventilate what their issues were in the first place. My lord, could I?
Just before that, so your concern is that you want that you read the Court of Appeal's judgment, the majority, as overturning the judge's finding of fact that the promise was made to her before the will was drafted, so the 1982-1989, that she would, that bit, he wanted her to have that bit when he died, the land on the hill. And you read the Court of Appeal majority as saying that discussion never happened, rather than, yes, that discussion may have taken place, but there's the will, that discussion doesn't actually give her any rights to any particular bit of the land, given that the will said what it said.
My lady, they don't, the conclusion of the last bit they come to, but they also say, and we overturn the findings of fact that this promise was made. We say...
The judge actually didn't find a promise made. The judge found the land was given.
Yes.
What you want us to do really is replace the judge's finding of fact by a different finding of fact, which the judge didn't make.
Well, in my submission, the Court of Appeal majority and minority were both correct in if you analyse the judgment correctly, what the judge meant when he says given was promised, because that was...
The pleaded case was that she was promised she would get it as her share.
As her share, so it must be a future...
That means after the deceased has died, not then, when the promise is made.
Yes, madam.
Right, so it's not, so there was no finding at any level that it had been gifted to her during the deceased's lifetime. There were problems with it not being in writing anyway. So it was still part of the land that was devised by the will, but wasn't her case initially that it had been gifted to her husband when they moved in there? That was rejected by everybody.
There is a distinction between the chattel house, the house on the hill,
house, yeah.
where we say there is at least documentary evidence that chattel house was given to her husband Omar.
Can I make sure I understand that a chattel house is a structure which is so movable that it's not really fixed to the land?
My lord, my learned friend helpfully put in an authority which gives a brief history in Trinidad of how that nomenclature arose. But essentially, yes. And so it
could, for example, be gifted otherwise than in accordance with the legislation governing transfer of land?
Yes.
Yes.
It doesn't, just because it's built on the land, it doesn't become the land like an ordinary house does here.
More like a caravan. Caravan without wheels. That you take to bits before you move to the next location.
Exactly.
Yes.
My lord, I appreciate that time is running away, but my lady and my lords, may I go on to the first point, which is the finding of fact being overturned. And we say that's the central issue, which is, did the deceased promise Vashti the land on the hill? The trial judge said yes, and the Court of Appeal said this is impossible, because that's contrary to what the will says, and we say that that's wrong. And we start with the test, the legal test for overturning findings of fact. The board very recently, with some of the justices here, recently dealt with that issue in the case of Rowley and Gift, which can be found at 1521 of the bundle.
1521?
1521.
Thank you.
My lords, my lady, I won't go into the details of the case, but sufficient to say that the board there affirmed the test in Volpe and Volpe for what is required for overturning first instance decisions. I'll ask you to just read from paragraph 3 and the Roman numerals below to go on to the next page.
Yeah.
So just give us a page again.
Starting, on page 1523. The test was affirmed by the board at paragraph 27. This is on page 1530. And the proposition which we seek to rely on is that an appellate court must not interfere with the trial judge's conclusions on primary facts unless satisfied that the judge was plainly wrong. It's not enough that the appellate court could have reached a different conclusion. Now, the trial judge here had the advantage of seeing and hearing the witnesses. The Court of Appeal did not. And to overturn the judge's findings of fact, they had to find that the judge's conclusions were ones that no reasonable judge could have reached. And as Justice of Appeal Raj Kumar, in his dissenting judgment in this case, correctly held, they failed to do that, and he does so at paragraph 109 of his judgment at electronic bundle page 813. I don't propose to look in detail at the cases which the respondent relies on for saying that the finding of fact should be overturned. But briefly, these are the cases of Samlal, which is at 997 of the bundle, Central Bank of Ecuador and Conticorp, which is at page 1004 of the bundle, and a Privy Council decision called Ramsaran at 1600 of the bundle. And the short point is that all these cases were very extreme cases, and which the present case is not. So in Samlal, what the judge found was that the claimant's case was inherently improbable. Those were the words used. This was to do with an import license being applied for and it being improbable that the administrative body granting the license wouldn't have seen what it was granting. Central Bank of Ecuador was a failure to consider contemporary documents, and what the board called what the Supreme Court called extreme improbabilities. Again, we say that's not the sort of decision.
And as I understand it, the reason given by the Court of Appeal for intervening was that the judge completely failed to address the fact that the deceased had made a will, and just didn't factor into the consideration of the evidence that suggested a lack of intention that that a parcel of land should be given to the respondent.
My Lord, I do get on to that, the fallacy in that reasoning, but I say it is similar to the Ramsarang case to the extent that what the Court of Appeal there did, which the board warned against, was simply relying on one document to overturn the finding. And in that case, there it was found that the set of facts that were being put forward by the claimant could not have been reasonably entertained. Now, we say we're not in that world of whether the promise was or was not made. It might have been a factor to weigh in the balance, that the will was made in the terms that it was, but we say it doesn't take it into that extreme territory. Now, the facts supporting the promise, the trial judge heard extensive oral evidence, found the first appellant to be a witness of truth, and she did so at page 428, paragraph 56. She found that the first claimant, who's no longer respondent's evidence, was undermined, and this is at 434 of the bundle, paragraphs 73 to 74. You say correctly, and she attached little weight to the sixth respondent's evidence and also to the evidence of the sibling's uncle.
What's the specific
example
finding?
was the 81-year-old gentleman.
82-year-old.
82-year-old.
Yes, my lord.
Yeah, so there's a dispute about how good his memory was.
Yes, my lord. I'm happy to address you on that now, but I propose to go through it in the order that my learned friend takes those points. But the evidence supporting the promise in my submission was a good one. The first appellant's own evidence was credible, that her father had made these promises at various times in her life and just before the marriage. Paragraph 17 of her witness statement.
That was before he made his will.
Before he made his, more than a decade before he made his will. But the evidence is also that he repeated the promise after he made his will.
Did he change his mind and change it back again? Or, these sort of points simply weren't addressed by the judge.
They weren't, Madam. And they weren't put in cross-examination either, as against... That point wasn't put in cross-examination against my clients either.
So on the finding of promise, what's the specific finding you're relying upon of the judge? Is there an express finding you're relying upon?
Well, it might be more helpful to take you to the express finding that the Court of Appeal overturns.
Okay, well, which is that then?
which is paragraph 85 of the judgment,
Page.
Of whose judgment?
of the High Court judgment. So this is at page, starting at page 436 of the bundle.
436.
Yes.
Thank you. Yes.
Well, a good reason to overturn that finding might be thought to be that it was based on a wrong understanding in law about the effect of the will.
Yes.
My Lord, sorry to answer my Lord Hamlin's question. You have paragraph 89 of the judgment, the conclusion.
89.
And you have at
So is what you're saying is that the judge was entitled to find that the father had said to Vashti, when I die, I want your portion to be the land on the hill.
Yeah.
And that was the finding
Yes.
made. And
Paragraph
the
50.
judge may or may not have gone wrong to jump from that to say, well, then she owns that. But there's no real inconsistency between that finding and the intention of the father, which was, I'm going to leave you all the land in equal shares, but when I die, everyone should know that I want you to have that bit. That was the finding. And the question of what legal repercussions that has, given the will, doesn't necessarily undermine the finding of fact that that was set.
So where is the finding?
sorry, my Lord, you have paragraph 56 of the judgment.
56.
And I appreciate here, as throughout the rest of the judgment, you have to read given as promised.
As her share, and as her share, I think, implies when he's died.
Yes.
Yeah. Yeah.
Right, so he's there, she's there talking about the evidence.
Yes, and accepting that as
Yeah.
Yeah.
truthful.
Okay.
Yeah. And that was the pleaded case.
Yes.
Yeah. I haven't looked at the witness statement. Were there written witness statements?
They were, my Lord.
Yeah, I haven't checked those.
And you had the
Yeah.
second appellant's corroborating evidence, and that's dealt with at page 429, paragraph 61.
So it's also, sorry, just paragraph 50 is where at 426, where she recounts the evidence of Vashti as to what had happened,
Yeah.
and 51, and then she says, I accept her evidence.
Yes.
So she's a witness of truth.
Yes, my Lord. And you also had the executrix's evidence, Chandra's evidence, that the deceased had told her to make sure that Vashti gets the land on the hill.
Yes. Does she say when that happened? Long after the will was made, presumably.
No, my Lord. If I could take you to page 157.
Yeah, judgment paragraph. 157.
157 is
Is that the witness statement?
the witness statement. And paragraph 17 is the relevant. After this is the last two lines of that.
Oh, I see. Oh, so it's absolutely contemporaneous with the making of the will.
And you have Vashti's evidence at paragraph 17 of her witness statement, which was that the promise had been repeated several times, and this is on page 169 of the bundle, again, paragraph 17. And you also had, for example, the 2014 email from the respondents, which can be found at page 344 of the bundle. And my lords, my lady, could I just give you a moment just to skim through it, and then I'll seek to extract the points from that email. My lords, my lady, if I may. The concern here is Vashti's family occupying land and planting outside of the confines of the plot that we say everyone knew they were to get or had been promised. There's a recognition of Vashti having a specific plot. You see that my concern is that this will extend the boundary of Vashti Ramlal's property. Recognition that such a plot has a boundary. For example, through the fence being erected at some point in the past, there's been, in practical terms, some sort of subdivision of the property. It shows the belief that once property is vested, it will vest in 12 specific portions, and Hollis will need to obtain permission of the beneficiary of that portion to undertake the work that he wants to do. So whether as a matter of law or not, it is correct that the way the will sought to dispose of the land, it didn't dispose it in specific portions. This is evidence of how, and this is being written on behalf of all the other beneficiaries, how the beneficiaries viewed how the estate was to be divided up.
They are sort of assuming there's going to be a partition at some stage, you would say.
They're assuming that the land will be partitioned in specific plots, and there's a recognition of what Vashti's plot is and is to be. The other evidence which the judge took into account in my submission correctly is the transfer of the chattel house to the second appellant. This is that.
From a legal perspective, this is all in a sort of parallel universe. This is 8 years after the death, and the estate hasn't been distributed. This life is going on, and the children of the deceased are making various assumptions. But it's got nothing to do with the law of succession.
My lord, it does have to do with the finding of fact that the promise had been made, because it shows. I appreciate the point you're making, and in my submission that is met with the proprietary estoppel point, but this is dealt with. That specific point is, and this email goes to whether the promise had been made, and the point put forward by the appellants, which was, and all the siblings knew it.
And I suppose you would say that, bearing in mind at the same time as the testator was making his will, he was saying to his executrix, make sure Vashti gets the land on the hill as her share. He may have been labouring in or living in the same parallel universe, that making a will in those terms and telling your executor to make sure a particular child gets a particular share is a perfectly legitimate way of doing it in Trinidad. However legally unworkable it may be.
My lord, I can't meet the point that you make, and my lord Lord Legate makes that.
No,
the terms of the will are what they say.
I thought I was making a point in your favour.
Yes, my lord, I agree, and I simply say that.
Yeah.
And that goes to the point about the fact of whether the promise had been made or not.
Yeah, exactly.
Yes. And then just briefly, you also have the transfer of the chattel house to the second appellant, where we say that's evidence of, and the judge at first instance was correct in seeing that as further evidence of the family really embedding itself on the land on the hill. And then you have the pattern of the deceased allocating specific portions, which was raised by Mr. Ramlogan, to the only other beneficiary who was resident permanently in Trinidad, which was the first claimant. My lords, my lady, my learned friend seeks to rely on the case of Gandy and Macaulay, which is also known as, in the case of Garnett. And this was a case about, for the proposition that the court needs to carefully scrutinise a claim that a fact attributed to a deceased. Here, in that case, the aunt's representatives argued that a claim against a dead person's estate cannot succeed based solely on the claimant's own testimony and must be corroborated by independent proof. The court rejected that as a rule, but did decide that the court should be jealous, have jealous suspicion, and sift through the evidence carefully. And as I say, corroboration isn't strictly required. In this case, in our case, it doesn't involve a case where there hasn't been corroboration. We say there's corroboration by, for example, the executrix's evidence. And we also say that here the judge did sift through all the evidence in deciding that the promise had been made. So that this isn't a case where the judge hasn't. The next issue is about the alleged inconsistency of the will with the promise. My Lord Milbriggs, I appreciate you've made one of the points in relation to that email and the which I adopt about it showing really there may be a distinction between what everyone presumed was a matter of fact versus what the law said. But the Court of Appeal's decision hinged on the idea that the will, which leaves the estate in equal shares, is fatal to the existence of the promise.
Yeah.
I take you to paragraph 30, this is on page 777.
This is the Court of Appeal.
This is the Court of Appeal.
Yeah.
They also use the word gifting, and it's not clear whether what they are disagreeing with is the idea that there was some gift of the land prior to the death, or a promise in the sense of the expression of a wish that that land should be hers.
My lady, we say that the Court of Appeal, both for the majority and the minority, both understood the judge to have meant when she referred to given or gift, that there had been a promise. And that is really the only interpretation of the appellant's case where they're whether she was saying that it was her share, it would be her 12th share of the total lands. So we say that there's a logic error in the Court of Appeal's decision. The deceased first promised Vashti the land on the hill as her share of the land over a decade before the will was drawn up. It's not inherently improbable or inconsistent that such a promise had been made, and it's not improbable that the father repeated the promise even after the will had been made. And that comes to the question of his and everyone else's understanding of how the estate might be divided versus its legal effect. Paragraph 85 of the judgment, which is at page 436 of the bundle, in my submission, could be expressed better. The judge then, the last sentence says, in my opinion, the will is a document which was consistent with the first defendant having the land on her hill as her share, since it did not exclude her from getting a share of the subject property. I think that's infelicitous drafting. It should say, is not inconsistent. And that makes sense when you get to the end of the sentence.
Sorry, which paragraph are we looking at?
Paragraph 85. This is on page 43. It starts on page 436.
436, I've got the page wrong.
And goes over the page.
Yeah. Well, it may suggest that the judge was labouring under a similar sort of misapprehension as maybe the testator was labouring under.
My Lord, I would hope that the court wouldn't presume such a thing.
Well, it didn't exclude her from getting a share of the subject property. Well, strictly speaking, it did, because every single one of the 12 beneficiaries was to get an undivided share in the whole of the land. But she may have thought that you could do it that way by leaving it to them in equal shares and telling your executor how to partition it.
My Lord, I say that the reading which is in my submission more accords more with what the judge was driving at is that it was not inconsistent with the first defendant having the land on her hill as her share, because it did not exclude her from getting a share of the subject property, i.e. if the will had not made our client one of the beneficiaries of the will, i.e. excluded her from receiving anything, that would be inconsistent with the promise either having made or been repeated, even after the will had been made.
Yes, but the judge seems to have assumed that just by making an oral promise, you could give somebody, you could make a gift that had legal effect after somebody dies, when they've made a will. But it doesn't contain that gift.
Well, I mean, that touches on our proprietary estoppel point of conclusion.
Yeah. But there's no hint of proprietary estoppel here. It just seemed the judge proceeding on the basis it was promised, that was a gift. You can square it with the will, so there we are.
My Lord, that's not our submission. Our submission is properly read. The judgment can be seen to be one acceding to proprietary estoppel.
But where you say the Court of Appeal went wrong was in saying that the will is evidence to show that there had never been that conversation between the deceased and Vashti.
Yes, my Lord.
What the legal effect of that is a different question.
Exactly.
But it doesn't undermine the evidence that conversation took place.
And if the judge was right to accept the evidence of the executrix, that at the time the will was being made, the deceased said, that the testator said to her, make sure Vashti gets the land on the hill as her share, it rather shows, if you accept that evidence as well, that he didn't think that the will was inconsistent with the promise.
My Lord, all I say is I see it can be seen in that way. Sorry, by he, do you mean the deceased, the testator?
Yes.
Yes, my Lord, sorry.
I mean, if I give you a will that says one thing, and I, at the very same time, say to the person who's going to be the executrix under that will, please make sure Vashti gets the land on the hill as her share, it rather suggests, unless he's changing his mind every 5 minutes, that he doesn't think what he's done in the will is inconsistent with her getting that share.
He hopes that they will all fulfill his wishes and his intention, but he doesn't mandate that in the will.
My Lord, my Lady, that touches on the partition point about this sort of declaration potentially influencing agreement between the parties.
Sure.
Can I just ask, just so, while it's in my mind, we don't overlook it, what about the planning position? You would need planning permission to subdivide the land, wouldn't you?
Yes, my Lord, we say that's a red herring. Yes. I'm happy to address you now on it.
It probably affects the form of the order, if we're with it. So we couldn't order the executive to do something unconditionally, for which you require, by statute, planning permission.
Yes, so the respondent submits that because a subdivision of land in Trinidad and Tobago requires permission, that means and because subdivision includes partition, and because the deceased, I'm trying to understand my learned friend's argument on this, but because the deceased was involved in court proceedings in which touched on that planning legislation, he must have known that he would have needed planning permission for partition, or permission for partition. We say we have 4 answers to that. The first is that the point wasn't raised below, and the appellants weren't cross-examined on it. The second is whether or not that's the law, it doesn't disturb the appellant's evidence, which was accepted that the promise was made and repeated. The third is the premise isn't correct. It's not correct that the father could not partition without subdivision. We say we rely on that Privy Council case, that Fiji case, Patel, which involved an ordinance in virtually identical terms, or the relevant parts in virtually identical terms to the...
This is the mysterious case from Fiji.
This was the 1954 case from Fiji. It involved identical words in their planning ordinance to the Town and Country Planning Act in Trinidad.
Okay. Is this case, this is not in the bundle, is it? Or is it?
It was provided to the...
Oh, the one last night?
It was provided last night.
Yeah.
The relevant wording of the ordinance there can be found at page 44 of that case.
But we don't have the Trinidad ordinance, I don't think, do we?
My Lord, you should also now have a full copy of the Town and Country Planning Act.
Yes, we've got that
was
act,
also provided.
Yeah.
But wouldn't the ordinary way to be to go, assume we do need planning permission, you'd first need to come up with a scheme of partition, and then you go and get planning permission for it.
My Lord, this decision effectively says the court can order partition,
Yes.
and then you go get planning permission.
Yes. Doesn't stop them refusing planning permission.
It doesn't stop, but it also doesn't stop this court ordering partition.
Yeah.
Partition and subdivision are separate things. There's also the point that this is in the context of subdivision being defined as a development. And what the Town and Country Planning Act does is gives the state the power to enforce its permission rights and requirements. And it has a 4-year limitation for doing so. So it doesn't make any subdivision void for not having had permission. It just allows the relevant authorities to enforce against it within the 4-year time limitation, which is at section 16 of the Trinidad Act. So, in the partition proceedings, work found that actually the land on the hill has already been subdivided as a matter of fact through its use or whatever. It's not fatal to that subdivision that it didn't have planning.
Is that because the actual partition is one thing, but subdivision involves some physical separation?
Exactly.
So you could leave a piece of land to be split into 2 and given to A and B in your will. It wouldn't be an invalid provision in the will. No. But before they actually put a fence along, they'd have to get planning permission.
Yes, but if they put a fence along before 4 years and 5 years had passed, then, well...
Yeah, okay.
That's how it lies.
Yes, so it doesn't. So the planning position doesn't prevent the making of an order, but it would prevent the implementation of the order.
Yeah.
Yes, madam.
In a nutshell.
Yes. Which the parties would need to go get.
It would not prevent the making of a petition order.
No. Sorry, the partition order. It wouldn't prevent the making of a partition order. No. And we rely on that authority for that proposition.
Right.
So just turning back to whether the judge in fact did consider the will, we say she did. She summarised the respondent's argument at paragraph 67 of her judgment. This is at page 432. She addresses it at paragraph 85 at 436 and then at 437. Paragraph 86 at 437. We say the Court of Appeal did not identify any respect in which the trial judge's conclusions were ones that no reasonable judge could reach. It simply substitutes their own view as to the promise. Dealing briefly with the other points raised by the respondent. The first is an apparent missing document which the respondents say wasn't dealt with properly by the judge. This is in the respondent's case, paragraphs 21 to 28, starting at page 955. Much is made of an alleged missing document showing that the lad had already been given. We say this is clearly a misunderstanding of the evidence given. If you go to page 633 of the bundle, which is the transcript of cross-examination, and this is cross-examination of Chandra. You'll see about halfway down, she's asked, but you know that there is a document in existence that says there is a transfer from your father to Omar. Here, the counsel must be referring to the transfer of the chattel house because the reference is to the tax record, which is found at page 35 of the manual. She says yes. He says, I'm putting it to you, there's no such document. I'm putting to you, there's such a document was in existence, that you were aware of it, and as executrix, will you not have done precisely what you ought to have done when you was doing the inventory? What do you mean? And then, and this is the part referred to by my learned friend. So you took them a document that your father, no, they had it, so they kept it. Yes, you're telling me that this is a document that that has my father last testament. That is what he wants. Yes. So at the time when you did you tell them that there were other documents that you have in your possession that would affect title to the property? No. At the time of giving this witness statement, did you tell the attorney at law that there was a document in existence? And she's asked, I'm putting to you, there's no such document in existence. She says there's such a document. In my submission, she's referring to her understanding of what the existence of this chit from the tax authorities was. My lords, my lady, I've already addressed you on the planning authority point raised. Finally, it said that it said that the judge failed to properly address the uncle's evidence in what's termed as the only independent witness. We say the judge was not wrong to attach no weight to his evidence because of his failing memory. We say he could not recall his own age. See at page 549 of the bundle. He's asked, this is about asking whose name was on a transaction. So you did not know that. I knew that. It happened about 60 years ago, and I'm 78 now. I was a kid running around. He was just around 18 years old, around that. You say he was 78? Now. You're 82. You just told, and he says he's 82 further up. You told me you're saying 78 now, which for your earlier discussion you said 78. So you have a little memory problem. Yes, I do. Not memory problem, I have a hearing problem. It can't be a hearing problem. He wasn't asked. It was him who volunteered that he's 78 now. It can't be a hearing problem. He couldn't recall his sister, the children's mother, having a job as a janitor. This is at page 552 of the bundle.
I think in the case what he's saying is when he... I don't know. Well, carry on.
Couldn't recall that his sister, the children's mother, having a job as a janitor. This is at page 552. And when cross-examined on there being another house on the land beside Debe House, i.e. the cross-examiner wished to start cross-examining on the house on the hill, the uncle says that they did not have another house. He flatly contradicts his witness statement. So you see what he says in his witness statement at page 553. Sorry, his witness statement is I'll start with the cross-examination. You have at page 553, did you have another house anywhere? Did they have this is the parents, have any house anywhere except in Derby by the Hindu school? That was my sister's house, and then they never had another house? Because he says no place else. No, sir, if she had another house, was the kid's house, she might go there occasionally to spend weekend or something like that. His house is where, sir? I can't recall, they have 12 kids. I'm talking about in Trinidad, sir. Did they have another house anywhere? No, not to my knowledge. On this land that you and your brother-in-law and sister, everybody purchased parts of it, did they have a house on that land? No, they did not have a house on that land. I know that land very well. I used to go shooting watermen there every morning. You're certain about that? I sure do. They did not have a house around there. So I mean, he's trying to start crossing, but this person can't even remember about the house on the hill, even though it's mentioned in his witness statement at paragraph 9, page 151. And we say that the Court of Appeal wasn't in a position to assess the demeanour of this witness. It's clear from the judge's position that this 82-year-old man's memory couldn't be relied upon. Regarding Hollis's evidence, which is what the first claimant is the name he goes by, he's content for the appellants to succeed in this appeal, and he gave evidence which wasn't accepted by the judge.
So which one is Hollis?
Yes.
The first claimant.
He was the brother who himself built a house on adjoining land to
Yes,
land on the hill. Yeah.
His full name, my lady, is Lutchmienarine.
Yeah.
I apologise if Lutchmienarine.
Yeah.
I'm grateful.
So that's the same person?
That's the same person. We say the judge was entitled to accept Vashti's evidence over his. By way of example, the judge accepted Vashti's evidence that her father had also pointed to a plot of land and promised that to Hollis and allowed him to build property there. And Hollis gave the improbable evidence that he didn't know the land was his father's. We say it's improbable. His father had owned the land since 1968. And this property was built in 1989, and built the house there without anyone's permission, and this is despite the father working the land and owning the property for many, many decades. It's also said that we also say the judge was entitled to attach no or little weight to the evidence of the sixth claimant, Krishna. We say that the judge was able to determine the demeanour between the witnesses and was able to, even if the court finds that the judge was wrong to attach no weight, we say the judge was entitled to prefer the evidence of the appellants. And we say the Court of Appeal and my learned friend are wrong to suggest that the judge reversed the burden of proof. The Court of Appeal say that it was reversed at paragraph 32 of the judgment, at page 778 of the bundle. We say the judge was always aware that the burden was with the appellants to prove the promise had been made, their entitlement. And this is at paragraph 49 of the High Court judge's judgment, at page 426. So the position was that the judge found our client's witnesses to be credible witnesses and preferred their evidence. And the defendants in that case simply weren't able to prove otherwise. It's not what the judge didn't reverse the burden in her remarks. So as I say on that point, we asked the court to either reinstate the High Court. We asked the court to reinstate the High Court's finding of fact as to the promise's existence, and that the deceased promised the land on the hill to Vashti.
But appeals are normally against orders. I'm just wondering procedurally how we do a reinstatement of a factual finding exercise. We can obviously say that in an opinion, in a judgment.
My Lord, if the board is with us on the proprietary estoppel point, then we say that's sufficient to restore the High Court
Yes,
judge's declaration.
because that depends upon the promise having been made. But if we're not with you on the proprietary estoppel point...
We asked for a variation of the declaration that we saw,
Okay,
which
yes,
was,
I see.
rather than entitlement,
Yeah.
we asked for that to be varied to what was promised by the deceased.
So you want to reinstate the promise by a varied declaration.
We say that in the alternative.
And that, you say, would be useful to her in a future petition application.
When reaching agreement with the other parties.
So what's the order you want us to vary, or the declaration?
The order of the judge is found at page 445 of the bundle. And it would be paragraph 2, Roman numeral 1, which we would, in the alternative, ask to be varied. If the court isn't with us, we have to accept entitlement would need to attach to some legal right.
Of course, partition application or agreement are two things. In between that lies a mediation, which I noticed that the dissenting judge in the Court of Appeal strongly recommended, without breaching any confidentiality as to mediation. Is there anything you can tell us about that? Is this a case where mediation has been tried and failed, or are we just not there?
My Lord, I can take instruction.
Maybe you can't tell me, because sometimes the very fact for mediation is confidential.
I'm not in a position at this point to
Okay.
say one way or the other.
Just to be clear, the variation is, rather than is entitled, is what
Made a non-binding promise?
was promised.
Was promised by the deceased.
Was promised by the
But
deceased.
you can only get judgment on the counterclaim if you can actually establish the legal entitlement to the land.
Yeah.
So it would need to be wrapped up in a recital that, having promised da-di-da, but nonetheless, if we were with you, that the promise had been made as a matter of fact, but not with you as to that generating any legal entitlement beyond what she's entitled to under the will, what would you say would be the correct course for us then?
Well, within these proceedings.
Yes.
Because we only sought declaratory relief. And as we know, there isn't merger.
Yes.
There isn't, that would be that would stand by itself as a declaration of the court as to a matter of fact.
Right. But that doesn't necessarily support an order for judgment for her on the counterclaim. That's the problem.
Presumably this isn't a declaration you ever asked for in your pleading. It's just something you think would be handy now.
That's something less.
Well, my Lord, we say, this is the proprietary estoppel point. We say, looked at properly, it was pleaded out, and...
No, but the relief you want in an action is something you have to put at the end of your pleading.
Yes.
And you ask for a certain declaration, and I don't think in your pleading there's anything that corresponds to what you're now inviting us to do.
In my submission, there is, in terms of our pleading, properly analysed, was that we were saying that a promise had been made by the deceased that we would have that portion of land as our 12th share.
And as part of your relief, you asked for a declaration to that effect, do you?
Yes, I mean, we only sought, we didn't seek transfer of any land, we only sought declaratory relief.
You asked for a gallon, but you may have to be content with a pint, I think is perhaps the way you're putting it.
And you would say asking for a gallon includes impliedly a request for a pint.
And this is assuming you don't succeed on proprietary estoppel. If you succeed on proprietary estoppel, we're in a different ballpark.
Exactly. Yeah. It might be opportune to turn to proprietary estoppel. We said that the law here shouldn't be contentious. Three elements identified in Thorne and Major and in my Lord Briggs's judgment in Guest and Guest. There has to be a representation or assurance made to the claimant, reliance on it by the claimant, and detriment in consequence,
Yeah.
reasonable reliance. And we know from guest and guest that the purpose is to prevent unconscionable conduct. And here we say proprietary estoppel was pleaded, and as a matter of substance. For that proposition, we rely on the case of Latang and Cooper, which is quoted in the decision of Zavarko and Nasir recently of this court at page 1651. It starts paragraph 35, which is 1661. That is, the cause of action is simply a factual situation, the existence of which entitles one person to obtain from the court a remedy against another person. And we also seek to rely on the case of O'Neill and Holland, which starts at 1338. Now, this wasn't a proprietary estoppel case. It was a case that concerned a common intention constructive trust, but did also deal with the issue of detriment there.
Sorry, which page are you on?
I'd ask you to look at page 1358, paragraphs 60 to 65. And the thing to take away there is that although the facts which constitute their detriment, here we say proprietary estoppel, need to be pleaded, their characterization is ultimately a matter for the court in light of all the evidence adduced at trial.
Proprietary estoppel, though, is about people who make life-changing decisions on the faith of promises and spend their life on the family farm or something like that when they could have gone off and would have gone off and got another job. It's not about people who get the benefit of living in a property for 20 years and then would like to keep it because it's been promised to them they'll have it after the person dies.
Well, my lord, we say that the appellants fall into the former category here, where they lived for many years in this chattel house and helped Vashti's parents grow crops on the land, and supported their parents for decades, in terms of looking after them, on the basis of the promise, and contributed to the taxes to do with the land itself and legal fees associated with land that wasn't that land as well, and expended money on the upkeep of the chattel house. We say that there may be a gradient between Thorner and Major and other cases, but we say we're close to the Thorner and Major side. The facts which we say make the proposition good, we say look at the pleadings, and the promise of representation is pleaded at, starting at page 24 of the bundle, paragraph 4b. It's also found at page 23 of the bundle, paragraph 3. We also plead an acquiescence of sorts at paragraph 4G.
Sorry, paragraph?
4G.
4G.
This is on page 25.
Yeah.
And 4O on page 27. And also paragraph 10 on page 29. And we say reliance and detriment are pleaded at, this is going back up to page 24. At 4B to E, G, J, and L to P. We have the remedy sought at it's sought at the end of the pleadings, and this is at page 30.
So where is the detriment pleaded as a detriment? It probably isn't, is it?
Well, it doesn't use those words, no.
No.
But it pleads what our clients did as detriment to themselves.
Can you help me on this? It's one thing to plead a set of facts as, if you like, supportive or corroborative of an assertion that something has been promised.
Sorry, my lord, could you repeat that? Sorry.
Forgive me. It's one thing to plead a set of facts as supportive or corroborative of a proposition that something has been promised to you. It's quite another thing to plead the same facts as amounting to detrimental reliance.
My lord, I'm not sure unless it was detrimental reliance, why we would be pleading all the things that we did for...
Well, because they're supportive of the case that the promise was made.
In the context of there being detrimental reliance.
Well, yeah, maybe.
I find it quite hard to see why it's detrimental to be provided with a place to live and just to pay the ordinary upkeep expenses as part of doing so, when you've got free property to occupy free of rent. I would call that a benefit, not a detriment.
Well, I mean, my lord, there are other cases where residence was provided free of charge and there was still detrimental reliance.
Or what would you say would be a good example of a similar case to this?
Well, we have the case of, and this is in the bundle. For example, we have Whaling and Jones. This is a case about a couple who lived together, and one of the partners had been promised an interest in one of the partners' business and property. He'd worked in the business, he had free of charge accommodation, had worked in the business, and was paid a low wage by, as a form of pocket money, it was called. There he received the benefit of free accommodation.
Well, is there evidence that here any of the appellants received less remuneration or gave up the opportunity of a profitable job in order to look after their parents? Is it that kind of case?
Well,
sometimes you get somebody who gives up their job, goes and looks after the mother or something, on the faith of the promise that they'll get the house when the mother dies, that sort of case. Yeah. Is it one of those sort of cases? That is this case, my lord. Our clients looked after the elderly couple's land and then them. I know, but did they give up something? Did they give up a valuable job or something in order to do that?
Well, I think that proposition is...
People look after their parents for reasons of love and affection and not just in order to get property after the person dies.
My lord, could I take you to page 1677 of the bundle, which is an extract from Snell's Equity. Uh, 1677. Just starting from the...
Detriment.
Yes.
12046.
The 12046, yes.
Yeah.
It has been emphasised that detriment is not a narrow or technical concept. Detriment need not consist of the expenditure of money or other equitable financial detriment, so long as something is substantial. In testing for detriment, therefore, a court does not undertake an exercise of forensic accounting, but is engaged in a classic evaluative exercise, and must stand back and look at the matter in the round. Where B's claim depends on having made a life-changing choice, for example, by spending years working on A's farm, then the court will probably be prepared to treat loss of an opportunity to lead to a different life as itself detrimental without requiring B to prove, or itself trying to determine quite what B would have done and with what consequences.
Well, it seems to me to state it rather well.
saying we undertook this life basically looking after our parents, and we don't need to quite prove what we would have done otherwise.
But that's thinking of cases like Guest and Guest, where the deal, if you like, is that it's not a contract. You stay and work on the farm and you'll get it when I die. But this is, oh, you've been thrown out by your new husband's parents. You can come and live in the chattel house and you will get this share of the land when I die, but not that, and therefore come and work on it, or therefore in any way change your lifestyle other than living in the chattel house. And it's much, much later, when the parents are very unwell, that it's pleaded that they, at the parents' request, went and looked after them. It's not suggested it was any part of the sort of quid pro quo for the original promise.
But the original promise did also include helping them farm their own land. So not just, so they didn't only farm their plot of land, the land on the hill, they also farmed the rest of the land for her parents.
But did Vashti and Omar previously work at a paid job for some third party, and did they give that up, or were they also working whilst they were looking after the parents and farming the land? Do we know about what their work record was? I mean, if you could say, yes, Omar was trained to be an accountant and then he gave it all up to farm the land and look after the parents, that would be one thing. But I don't know if there is anything in the witness statements about their...
My lady, I can say there isn't anything in the witness statement in terms saying this is what we gave up to do it. But there is numerous examples of all that they did and expended themselves in reliance of that promise, both in money and time and their labour. We say that's enough for this overall evaluative exercise. So we say that the Court of Appeal, when they were looking at examining the question of proprietary estoppel, were wrong to say that there was not detrimental reliance, and they say this at paragraph 13 of the judgment, page 780. So we say the appellants occupied the land on the hill for over 22 years. They repaired and maintained the chattel house. They cultivated the land around the hill and the surrounding estate lands. Cared for the first appellant's parents, cooking, cleaning, nursing. And in 2004, they moved to become full-time carers for their parents, so they were caring for them prior to that. And the appellants contributed to taxes and legal fees associated with the overall estates. And as this was put in cross-examination by counsel for the claimant, for the respondents, that Vashti was treated as Cinderella by the parents and by all the other siblings. And it was put in cross-examination, and she agreed. This is that they were putting their lives away, apart aside, to live with mother and father and take care of them. Page 627, 628.
So this is cross-examination of who?
I believe it's Chandra there.
Right.
So this is being put to who?
It's been put on behalf of your clients to the child who's the executor. Is that right? Executrix.
Who's cross-examining?
No, cross-examination is being under... The executrix was our witness. She wasn't being cross-examined by...
Oh, right.
No, so it's cross-examining by the
By their counsel, yes, exactly.
Right.
Yes, this is cross-examination of Chandra, executors.
So it's their case that they were putting.
So their case is that they spent all their time, instead of working and earning a pension or putting aside savings for their own old age, Vashti and Omar, they worked taking care without pay for the parents on the assumption that when the parents died, they would get the house on the land on the hill, and that would be take care of them for their old age.
Just to note also, Vashti was also cross-examined using similar language at page 597 of the bundle at the bottom.
597.
597, the bottom of the page. And going on to 598. In terms of prejudice to the respondents, we say the facts making up the cause of action were set out in the pleadings. The respondents themselves recognise, we say, the substance of the claim, or the risk of proprietary estoppel actually being here, and they tried to meet it by taking a pleading point. They say that they submitted that the appellants had not raised or established an equity or estoppel. This is at page 370 of the bundle. We say they had the opportunity to cross-examine our witnesses on these points, and in fact, put some of those points in cross-examination to them. And the appellants weren't shaken. And it's noted that, it should be noted that Chandra wasn't actually cross-examined on the promise itself and her witness statement as to promise having been.
But what is the document at 370?
These are the written submissions of the claimants, of the respondents.
At?
In the High Court.
Trial?
At trial.
Written closing submissions?
Written closing submissions. It starts on page 362. We say that the appellants clearly set out the declaratory relief they were seeking at the end of their counterclaim. We say, in circumstances, the greater prejudice would be to the appellants in not ensuring that the siblings' father's promise was upheld. Again, just briefly to address the points raised by the Court of Appeal for why they say there wasn't detriment. The rent-free point, in my submission, we answered that with we say that isn't a bar to detriment. We have the case of Whaling and Jones, where they're the claimant lived rent-free in the relevant properties. On self-interest and the fact that the appellants had improved their own home, we say that's not a bar to detriment, and we rely on comment in Snell's Equity at 1677. This is starting where it says, it has been suggested that relevant detriment cannot arise from B's expenditure on his or own land. We say, read that as his or own house. Here we have the chattel house.
Sorry, page?
Page 1677 of the bundle. This is part of the 12046 of Snell's Equity.
What are the judge's findings of detriment that you rely on? Which is presumably where we should start in any approach to the legal analysis.
My Lord, we say that the judge accepted that our clients did what they say they did.
So we should look to their evidence to see what that was.
And She summarises the appellant's evidence. I think we've already been there at...
Right.
Starting paragraph 50. And then ending paragraph 56.
Okay, thanks.
And we say pleading out all that reliance and all that detriment, we say the clear implication is there that they did all those things on reliance on the promise. On the issue of that they'd only partially contributed to the cost of the property, we say that isn't a bar to detriment, and we look to the case of Inwards and Baker, which starts at 1286. In Inwards and Baker, the son contributed, I think it was just under half of the total costs of building the relevant house on the property. And detrimental reliance there was found. My lords, I think you really have the point about unconscionability.
What about the expenditure on the new, partly completed and now ordered to be demolished house? Was that undertaken before there'd been any challenge to the fulfilment of the promise? Obviously, the parties knew what the will said by that stage.
So my lord's question is...
I'm asking whether the work or money spent on the new concrete house, which was stopped by the agreed injunction, can be relied on as detrimental reliance.
My lord, that was money expended by the son, by Ravi, I believe.
Yes. Oh, so you say it wasn't by Vashti?
It wasn't by Vashti.
Right.
So you don't rely on that as detrimental reliance by her?
My lady, we don't need to. But as a matter of law, we said probably the detriment has to come from the person so entitled.
Okay.
I know I've got just under 10 minutes left of time. I just want to briefly deal with the demolition order.
Yes.
So following the Court of Appeal's judgment on the 30th of June 2023, the Court asked for written submissions on relief. This is found at page 782, paragraph 43.
782?
782, paragraph 43. My clients submitted that the status quo should be maintained, and they sought orders for a survey, and this is at page 822 to 827, but specifically 825, paragraph 6F. And critically, the respondents stated unequivocally at paragraph 11 of their submissions in response to the court's invitation for submissions about what order to give. This is at page 831, paragraph 11. They said, in the spirit of compromise, none of the now respondents wished for the house constructed by the third appellant to be pulled down or removed. And they put together two alternative options. And that's at paragraph 13 of those submissions, on 831 as well. So despite that being the position, on 8th of December 2023, Court of Appeal ordered the concrete house to be demolished. You say that's wrong because it's not an order that the parties sought. The respondents say they expressly didn't want it. And the court should decide issues between the parties as to what they're putting forward to them. Secondly, we say the survey evidence filed by the respondents themselves showed that the area occupied by the appellants is less than a 12th share.
When was that filed?
That was filed before the order of the court. Well, I think it's set out in our chronology.
No doubt. But was it before the Court of Appeal's order?
Yes, my Lord. 24th of November, the court's order was on the 8th of December. So the court, when it made its order, knew that the house was being constructed on less than a 12th portion of the land.
That's just an area.
Yes. It knew that the lands on the hill in which the construction was being made was less than a 12th.
So that the allegation of that her claim was actually more than a 12th had been shown not to be right.
By that survey,
But
which was put in by the respondents themselves.
But that assumes that that people were thinking of 1/12 in terms of area rather than value, when the hill was probably worth more per square perch than the swamp.
We don't have evidence on the value, but we say that, I mean, looking at the pre-action correspondence in 2016, the concern was over that construction spilling out over the boundary of that had been ring-fenced, as it were. The trial judge and the Court of Appeal had all found that the appellants were not trespassers. Fourth, the executrix had permitted the construction as the legal title owner, as the legal title holder.
But suppose that all she had, suppose there'd been no promise, no proprietary estoppel, all she had was her expectation of, all she had was the expectation that she would, when the will was went through probate, she would have a 12th share of the total. Would that be enough to prevent her being a trespasser, or prevent any of them being a trespasser on any part of the land?
The finding was that they had permission to be there by the previous owner and by the executrix. So trespass wasn't. That's why trespass failed both below and in the Court of Appeal and the High Court. And the finding was also that Ravi had permission by the legal title holder to build the construction. So, I mean, in any event, the Court of Appeal really should have been making any order as against the title holder.
One doesn't know whether the structure improved or didn't improve the value of the land, even if it had to be sold as a whole and the proceeds divided.
We don't. I mean, we have information. We have evidence as to how much money was expended to build the structure. I think it was. I believe it's about $400,000 or $500,000 Trinidad dollars. My lords, my lady, it was in a witness statement filed by Ravi in the Court of Appeal proceedings. I will endeavour to briefly bring it to your attention in reply.
Is that a 10-to-1 exchange rate, roughly?
Sorry?
Roughly a 10-to-1 exchange rate?
I'm not sure.
No, I can't remember either.
About 8-to-1, I think.
Maybe it was 8-to-1.
Something like that.
As I've given the planning permission point as well. That's a matter of enforcement by the relevant authority as well, and there may well be a limitation issue were they to try and enforce. Isn't for the court to do the government's job. My lords, my lady, I'm happy to rest there unless you have any further questions and give my learned friend a bit of a run-up before the break.
It would certainly help me if you could dig around and find the partition documents of Trinidad and Tobago to the extent that it's still in force. I think my guess is that the Trust of Land and Appointment of Trustees Act isn't in force in Trinidad and Tobago, but I may be wrong about that as well.
There isn't an equivalent, I understand, to the 1996 Act here.
Is there?
No, there is not.
There isn't. No, that's what I thought. So it would help me know what the power of an executor and or of the court is to partition a specific gift forming part of the as yet unadministered estate of the deceased if the beneficiaries to whom it's left in equal shares aren't all in agreement? I mean, you don't need to go into detail, but unless there is some power, I'm not sure what us solemnly declaring that there was a promise that had no other legal consequence would be worth for you.
My Lord, I will endeavour to do that, but just to answer very briefly as a matter of logic as I see it, where you had the courts, through statute originally in this country, being granted the power of partition. It was only in the 16th century, it was only in the 19th century that they then, in partition proceedings, had the power to order sale. It must have been in prior partition proceedings that there wasn't agreement between the parties as to how the land should be divided. So that being the case and the court couldn't sell, then there must have been a power to divide.
I can understand as a historian where you're coming from, but I just need to see it in black and white.
Yes, my Lord. My Lord, I'm happy to give way to the interested party.
I mean, for all we know, I mean, for example, it could be a statutory requirement to have planning permission. I mean, who knows?
Sorry, my Lord.
We're being taken to a case from Fiji. I mean, it's absurd being taken to a case from Fiji in the 1950s and not being taken to the legislation that actually governs this in Trinidad.
My Lord, as I said, I apologise. This was a point raised a few weeks ago by my learned friend. I'm happy to draw... As I say, the wording is virtually identical to the Fiji Ordinance as in the Town Planning Act, which the court now has, the Town Planning Act, before it, which we provided yesterday.
That's the planning point. I'm more concerned with the partition point.
Madam.
But you would think if it existed, it would be being done all the time, and there would be lots of Trinidad cases recently about families, with judgments saying this is how we're going to petition the land because the children can't agree. You would think that would be frequently done.
My lady, as a matter of how often these things go, and I don't want to prejudge how this might go in a partition proceedings, but often what happens is when there isn't agreement, there's an order for sale. Our position is that the declarations that we seek, enforcement it doesn't arise, but the declaration we seek may assist all the parties when coming to either an agreement or to the court. But that's our position.
Well, we're most grateful, Mr. Goldblatt. Unless Mr. Ramlogan has anything he wishes to add, we'll adjourn then for a short time and aim to resume in about 20 minutes.